Here we go. Chapter 3, Medical, Legal, Ethical Issues. You're going to be dealing with this a lot. The preparatory stuff is going to be basically the same as the first two chapters. We're going to talk about consent refusal, some confidentiality issues. You should have gone over that in your HIPAA videos that you should have completed by now. Any advanced directives, including DNRs. I just want to point you to one thing. A tort here in criminal actions, that's a civil case. Evidence preservation was basically consists of making sure it's in a brown paper bag, not a plastic bag, and then any sort of legal responsibilities, along with the mandatory reporting issues, the ethics, and the principles and the obligation to have some intellectual stuff. Okay, one of the main principles that underlies medicine, not just emergency care, is first do no harm. We try and do that as best we can with the knowledge that we have, the scientific knowledge that we have. So anytime a healthcare provider usually is trying to avoid legal exposure, it's because you're acting in good faith, and it's according to the appropriate standard of care, which is all EMTs are trained the same, and they render the same care to the patient, and it really shouldn't be that different between one EMT and the other as to what care is provided. So that's one reason to standardize education here. So you need to have the appropriate standard of care for the patient. Any EMT would have done this and that sort of thing. Consent is permission to render care. There's several types in your book, which you will have to know. But anytime you render care to the patient, they have to give their consent so long as they're conscious. But there's different kinds of consent, and one is for if they're not able to be conscious, or if they're not, in their right mind, basically. So if they're rational, right, and they're conscious, they have a legal right to refuse whatever care they want. Right. The sort of foundation principle is decision-making capacity. Now, you got to make sure that the patient can understand the information you provide, and you provide all the information that they need, and that's how they actually make an informed decision in any sort of medical thing. So you might not tell them all the information and they refuse. That's not really decision-making consent. You have to tell them everything. Now, capacity is a legal term. It's determined by a judge, but it's sort of interchangeable in a colloquial sense here. But a patient has autonomy. They have the right to do what they want. They have the right to refuse care and make whatever decisions they deem necessary for their own medical care, including refusal of care. Right, so one of the things about consent is express consent. Okay, this is when the patient actually tells you you can or can't do something. So they can do that verbally, or they can do it by things like when you tell them, I'm going to take your blood pressure, and they hold out their arm. That's express consent. They're expressing with their body that they consent. But to be valid, the patient must have informed consent. They have to have full information about this stuff. You explain the actual treatment, the risks, the benefits to the patient. Okay, so it's important to actually tell them the benefits that they're going to receive, and any sort of harm that can happen with any side effects, something like that. All right, implied consent. Now, this is when a patient is unconscious. They're unable to actually give full consent. What you're basically doing is assuming that if the patient was conscious and had their full faculties, they would actually have express consent for you. But in this particular case, the patient's unconscious, or they're not in the same mental state they normally are, or they have dementia, or they're on drugs or alcohol, that sort of thing. They're otherwise incapable of making a fully informed decision because their decision capacity is limited. This includes things like giving children treatment because they're not of legal age, they're minors. All right, we usually treat them based on informed consent, especially if we can't get a parent. So you never use this unless there is threat to life or limb. All right, so remember that. But the principle is known as the emergency doctrine. You're not going to hear that term emergency doctrine a whole lot. It's mostly just implied consent. But try your best, like I said, to get a parent or a power of attorney, spouse, somebody to actually give you consent. So involuntary consent is for people who are mentally ill, all right, or they have a behavioral crisis. This will include things like suicide attempt. All right, you can never assume that someone who has made an attempt on their own life actually has full information. We're not allowed to do that. Or people that are mentally delayed. They may have some sort of medical condition they're born with that they can't give like full express consent. All right, so in those situations, you obtain consent from the guardian and conservator. This can include things like prison staff, because they can actually give consent for the prison patients, but you should always advocate for the best thing for your patient. So if your patient refuses care and they're able to do that, you should actually, advocate for your patient. But it's not always possible to find someone who can give you consent. Say you can't reach parents, that sort of thing. So understand your local protocols and provisions, the laws on this. All right, and you will be taught that at your work. Usually things like minors who have, legal definition of that they're emancipated, they can actually refuse care if they want because they're actually legally entitled to do that. Or minors who are in the military, because minors can join things like the Army Reserve, and they can get injured or something like that. And then minors who, are actually pregnant. So anything that involves the child's welfare, that minor can refuse. All right. Yeah, and here we are, minors of consent. Yeah. Parents or legal guardians give consent in some states. This includes Oklahoma. It also includes married minors, by the way. So armed services, that sort of thing. Parents, so long as it actually involves something that involves the child. So if there is a mother who is 16 years old, she can actually refuse care for her child, all right, even though she may not be able to for herself. All right. Teachers and school officials may actually act in the place of parents. I believe the term is locum parentis, something like that. It means in place of parents. Anytime you see these Latin terms with the legal stuff, it's because of the side. But if a true emergency exists and no consent can be given, basically you can't contact the parents, treat the patient. All right, don't wait around. We operate on the principle of implied consent in those cases. Forcible restraints is sometimes necessary with combative patients, but they have to be somebody who is actually a threat to either themselves or others, and you're going to have to document why you think that threat is present very well. All right. Sometimes when you have these actual restraints, contact legal, you have to contact medical control and get permission. Many times it requires law enforcement. Anytime a subject is arrested, usually the police officer or even you yourself for your own safety are going to want these patients to actually be restrained. Now, sometimes that can mean the police officer wants to put the handcuff on the stretcher. Just remember they have to follow you to the hospital because they have the key to that thing. They can't get off your stretcher without it. All right. Some things like this happen. You're going to have to know your local protocols on this. Enforceable restraints, it's always best to contact ALS. Right? Because anytime you restrain someone, physically, even if you're using soft restraints, they can actually injure themselves fighting against them. So we want to actually sedate them, which basically means kind of put them to sleep so they're a lot more calm. Right? But once you apply these restraints, you don't remove them en route unless there's an actual risk to patients. This often doesn't happen with soft restraints, but they can get out of these restraints sometimes, so you have to know how to do them well. A lot of times the fire department on scene, because they're the ones who know how to tie knots, are the ones who actually do this. And they have a lot more experience than you probably will. So maybe the first time, watch them, ask them to show you, or even better yet, when you start work, have your partner show you before anything actually happens, so you know how to do this. Right? The right to refuse treatment here. Any conscious, alert adult that has decision-making capacity has the right to refuse treatment, even if their refusal means that they could die. Right? So this happens a lot of times with people that are usually older. Even patients that you say, "Hey, sir, you're having a heart attack." If this person is within their right mind, they can say they don't want to go to the hospital and they don't want to be treated. You got to treat that patient according to your protocols. So perhaps someone does this. You tell them they're having a heart attack. Their wife's there. They want them to go. You sit there for 30 minutes and they refuse. what you might have to do is just sit outside their house in the ambulance until they actually go into cardiac arrest, and then you could use implied consent because the wife's going to give you permission to treat. That sort of thing happens from time to time, not very often, luckily. But calls and refusals are frequently litigated. So any refusal that you actually get, you have to document well. Right? You have to be very thorough in your paperwork and try and involve online medical control whenever you can. All right, so assess the patient's ability to make an informed decision. All right, so you had to ask them and then repeat questions over and over. All right, you assess the patient's answer. Is this an actual answer that applies to the question that we've just asked? And observe their behavior. All right, all these things kind of go together in making your decision, and they'll be well laid out in your protocol. But if the patient appears confused or delusional, don't assume that the decision to refuse is an informed consent. Okay, they may not have full decision-making capacity as we use it in medicine to actually do this. So you have to take that into consideration. But you also have to know that it's not illegal to be crazy. So just because someone has a behavioral problem, they may not be a danger to themselves or others. Right? So you kind of got to walk a tightrope here and figure out what the actual policies of the department and the laws of the state are to practice. Providing the treatment is a much more defensible position than actually failing to treat a patient. But don't injure yourself in doing this, and use the assistance of law enforcement as much as you can. Right? So if someone is drunk in public, and you get called by the cops to transport this person to the hospital, and your protocol says this sort of patient who has had alcohol, who can answer these questions, and have these sorts of vital signs can make informed consent. Well, a lot of times what's going to happen is the police officer is going to tell them, yeah, that's true, you can refuse to go to the hospital. But what's going to happen is we're going to charge you with public drunkenness and either put you not in jail, but kind of in the drunk tank there, or you can go to the hospital with them. And they'll usually choose to go with us. That happens a lot of times. Right? So don't be surprised when that thing sorts of happen. But before you leave the scene, where there's been a refusal, always ask several times to be allowed to transport them, allowed to actually give care. All right. These people have to sign a refusal care form. If there's a bystander on scene, you can get a witness signature on that form, which basically means that they saw the patient refuse care. All right, and they'll actually agree with you that the patient has refused the care. Okay, so they're very valuable in this situation. And like I said, document this kind of stuff well. And this is what we saw. All right, this is what their mental state was. That's what it is. Now, confidentiality. You've gone over ahead the video, I do believe, in the assigned videos that you have. But just make sure that confidentiality basically includes everything. It can include the age and sex of the patient. All right, anything you found, any sort of patient history, what happened, all right, anything you did for the patient. Basically, everything is confidential for you. All right, especially don't post anything. Don't post anything about what you do on social media. It's just going to get you in trouble. Information that can't be actually disclosed, except if the patient signs a release, which happens from time to time for legal reasons. They'll sign a release for things like the lawyer can get the patient care report that you made, that sort of stuff, that their spouse can actually view this stuff, that the insurance company can have this. That's one of the signatures you get at the end of the call. If there's a legal subpoena, they will give them, so long as they have the subpoena, whatever lawyer asks for it, they will give the patient care report to the side, the prosecution, the defense, whatever. And if it's needed for billing personnel, like I said, that's going to be for the people that work in the ambulance service that are like certified ambulance coders, and for insurance companies because they have to actually bill based on what's in your care report. So what you put in there can affect actually how much money your service can actually get back. Okay, HIPAA. So it's about patient privacy, yes. It's also about the healthcare, actually being able to move that between like providers and things like that. But we're mostly concerned about the confidentiality stuff. It really strengthens the privacy laws. It includes things like computers. They have to like actually have sign-ins. You have to protect the data from breaches, that sort of stuff. So it safeguards the patient confidentiality, and it's the purpose is to protect their health information, so that not just anybody can get it. So failure to like actually abide by these rules of HIPAA, you can be charged a hefty fine. I think the minimum, maybe it's the maximum, is something like $10,000, and that's for you personally. So you can't talk about things where the general public can actually hear. All right, but the general public is often permitted to record identifying and protected information and images. Okay, so understand that. And social media, just don't do anything on social media that actually has anything to do with EMS work. It's just too much legal problems, and you can get fired. If you get fired for posting something on social media, whatever job you're applying for next is never going to hire you. Basically, the only thing you might be able to do is actually put where you work on there, but don't show yourself in uniforms or vehicles, nothing like that. Free speech doesn't protect you in this because of things like HIPAA laws. All right, the hospitals, the ambulance service don't want anything to do with it because the fines are hefty. Or advanced directives. Advanced directives can be like sort of two general things, but mostly what you're going to find is advanced directives. They might say they have something like a living will. This basically means what treatment will they accept for a hospital or an EMS worker to actually do if they're incapacitated and can't make the actual decisions. So a lot of times it's going to include things like they don't want a breathing tube placed. Okay, those sorts of living will things, certain procedures they don't want the hospital to do. Now, a DNR is an advanced directive, all right, but it's a special kind. It's a do not resuscitate, but that does not mean do not treat. So if you can actually save this person by using a BDM, like without doing CPR, that means you actually treat them and help them with things like that. That doesn't mean don't treat the patients. Okay? It just means they don't want CPR. All right. Yeah, other names. Living will, like I said, healthcare directive is used the more legal term that we use. But for a DNR to actually be a valid legal DNR, the patient has to sign it. Usually a lawyer has to sign it. And probably their doctor has to sign it. Now, hospitals will have pre-made DNRs where the patient or the power of attorney can sign and then like a doctor can sign. All right, so there's signatures of the physician or a healthcare provider. And then DNRs sometimes do have dates where they expire on them. So make sure you check all these things. Now, if a family says that a patient has a DNR whenever you show up, they must produce that document. Okay? So it's important that you actually have that in hand and you have seen it and you have checked it, or else you're going to have to actually start CPR. So in this one, there's actually a photo. It's important to know that the state of Oklahoma, has a pre-printed boilerplate DNR form. DNR form, that's the one you're going to see most of the time. Before we go on, one legal issue that actually comes up with DNR forms. So sometimes you're going to get on scene, and the patient is going to have a DNR form. And the family is going to tell you they have DNR. They may even produce it. But then the family is going to tell you they changed their mind and they want you to perform CPR on the patient. Okay. In this situation, unfortunately, what we have to do is go against the will of the patient because they're unconscious now and use the legal representatives, the spouse that's there, that sort of thing, and actually go against the DNR. If they do that, what you need to do is have that family actually tear up that DNR, like in front of you. And then you know that they really mean it. All right. It's an unfortunate situation. It's not one we'd like to get into. And it's one where we might actually spend some time telling them that that's not what they wanted. All right. But be prepared for situations like that. They occur sometimes. As always, follow your protocols in situations like that. That's the sort of question you need to ask when you first join a job. All right. Physician orders for life-sustaining treatments. Okay. Medical orders. All right. These are the interventions for the patient that are acceptable. It has to be signed by an authorized medical provider. So usually doctor. It could be their doctor. And then you contact medical control from addicts. All right. But it's the interventions you can do. It's that advanced directive living will, that sort of thing. Sometimes it has silly things on there, such as they don't want you to actually do chest compression, but they'll let you defibrillate. Well, if you don't do chest compressions, I'm going to tell you defibrillation isn't going to work. All right, but these things are made up by lawyers, and they ask the patient long set of details on what they want or don't, and it's signed by a medical provider. So some of the patients may have named surrogates to actually make the decision. These are medical powers of attorney. Happens a lot of the time. So these people have legal documents, and you need to see those as well. So if there's a spouse that has dementia, the wife or the husband or whoever is going to have an actual healthcare power of attorney, which is what it's typically called here in Oklahoma. And the form should say healthcare power of attorney because there are powers of attorney just over finance. So you need to make sure it's for healthcare and it's on the form of that. All right. Due to the growing number of hospice patients, because, those baby boomers, they're aging, you're going to face this situation.